Hi everyone, thanks for coming back after the break. My name is Roya Ramanpour from Barnes & Thornburg LLP, and I'm going to introduce the next moderator, Dan Stone. Dan is a litigator and trial lawyer at Greenberg, Glusker in Los Angeles. He was part of the trial team that represented Shelley Sterling in the probate court action that resulted in the $2 billion sale of the Los Angeles Clippers. Dan handles a variety of entertainment, media, media and copyright disputes, and has represented the Ray Charles Foundation, writer-director Ryan Johnson, Red Bull, and Universal, among others. So thank you, Dan, and I'll let you introduce the speakers.
Sorry, I just wanted to clarify the texting for questions does work, so please do that. It totally works, so sorry. Thank you, Dan. Sorry.
You've got plenty of time to formulate your questions.
I just wanted everyone to know they can do it, actually.
Great. Thanks, Roya. So,
Failure.
failure. Right, so we're about to go from a very analytical place to a very human place. But before we do that, let me introduce my panelists. Starting from the closest person on my left, Kiren Ahuja is a vice president of business and legal affairs at Studio 71. Studio 71 produces and distributes content, including such notable online personalities like Lily Singh, Logan Paul, and still Epic Mealtime?
Yeah.
All right. Right next to her is Daniel Kim. Daniel's an executive director at 21st Century Fox, who works largely with their content protection department. He's the non-lawyer on the panel, so he'll have some interesting things to say. And finally, Marjorie Williams. Marjorie is the Vice President of Business and Legal Affairs at Endemol Shine, which is a well-established producer and distributor of reality TV content, and also produces programming for outlets such as YouTube and Hulu. To sort of demonstrate how we're diverging from what the last panel addressed, I just thought we would start off with a story of two social media influencers who live together. We'll call one Mr. Popular and the other his friend, right? Mr. Popular and his friend are both about 20 years old, and they're roommates. And because Mr. Popular is so popular, and because his friend is not quite as popular, his friend started to spend most of his time filming Mr. Popular's content. Well, one day, as 20-year-old roommates do, they get into a fight. His friend grabs a USB drive, plugs it into a computer, and takes about 3 months' worth of Mr. Popular's content, photos, videos, so on and so forth, and leaves the joint residence, the apartment, and walks out with a bunch of content, which Mr. Popular realizes has been taken by this other person. Mr. Popular is so popular that he has enough money to hire a lawyer, and then hires a lawyer who promptly brings a copyright infringement lawsuit against his friend. And I ultimately took over the copyright infringement case because the lawyer who filed it, while a great litigator, was not really a copyright lawyer. And my first question to Mr. Popular was, okay, where are the agreements between you and your friend? And he goes, what are you talking about? We just do stuff. And Mr. Popular hadn't heard about what a work for hire agreement is, didn't think about what rights the friend may have in the content, who owns anything. And so what was a copyright infringement matter ultimately turned out to trying to negotiate a settlement to make sure that Mr. Popular had all of the rights in his content that he thought that he had all along. The other interesting wrinkle is when I called up the friend who didn't have enough money to hire a lawyer to try to negotiate a settlement, he wouldn't call me back, and I got a call back from his mom. His mom was a nurse, and his mom told me, I'm going to negotiate with you to try to settle this case. And because she was a working registered nurse, our settlements had to be during her breaks, during her shifts. And, in a situation like that, it becomes very human and not quite as legal, with the mom trying to protect her son from consequences. And thankfully, we ultimately settled that and everything was resolved. But I think it's illustrative of the sort of ecosystem that digital content is living in. And with that, I will present our first question to our panelists. To what extent do influencers and people who are working in content creation understand the legal implications of what they do for a living? And I'm going to turn it to Marjorie first.
Well, of course, the legal answer is it depends. It really depends on, to me, the level of sophistication of the parties, because I really find you have really now, especially kind of two types of parties, either the highly sophisticated influencer that may even actually be rep by an agent or a management company, may also have legal representation, and then there's the 20-year-old or even 12-year-old, Mr. Popular and his mom, who initially had just been creating content for fun, but are now starting to monetize it. And so, with that, there comes a myriad of issues, and just to highlight some of the ones that I know we'll get into further in the panel, the key thing that I think Dan brought up was about ownership. And even as simple as if you're using a cell phone to create content, whose phone is it? Who ultimately owns what you're actually recording? In the past, I was explaining, prior to prior years, companies and outlets like YouTube didn't care about who owned the content because their business model was tied to just the advertising that was supported against the particular content that's put up. But we're starting to see a shift with companies like YouTube and Facebook, who are now jumping into creating their own original content. And in those scenarios, they actually want to own the content. So that's one of the big shifts that I've seen just in the last this last couple of years, but even in 4 to 5 years, ownership is key.
And Kiren, I'm sure you have some input on this too. What's the level of sophistication you see out there?
Well, I agree that it depends on, like Marjorie said, the level of sophistication of the influencer that's involved with whatever content is being posted. However, I have seen it even for some of our top creators where they have that agent, they have that manager, they have a personal attorney, and they're still getting hit with, trademark infringement claims or copyright infringement claims. So there's still a basic lack of understanding, because I think these influencers are very used to just recording and posting, and they've done this their entire life before they were able to monetize, and they don't really think through those issues even when they have those representatives. I've seen, at my company, we represent around 1,300 YouTube channels, and there's like a very wide spectrum as to what the level of sophistication is for those parties. On one end, we have top performers who have their own personal attorney, and they get hit with these claims, and they are like shocked. One example that I have is we work with Logan Paul, and he created this music video with this kid where he basically, it was the kid was basically singing this song about how Logan Paul is his hero. They made this whatever music video together. And about 2-3 months later, the video performed okay. And about 2-3 months later, they got a trademark infringement letter saying, hey, you use this kid's trademark. He's actually a musician, and you don't have any consent to do that. That was an issue that ultimately we deferred to Logan Paul's personal attorney to handle. So how that was resolved is it was handled by his personal attorney, but it was an example of even a high level ranking talent who is still unaware of having to get those proper releases, like you said, a work for hire agreement in place.
So I think that's actually a good transition. I'm going to go up to the podium there in a second. But, people who post informally sometimes don't realize the requirements that go along with their content. And one area where this has been coming up is inquiries by the Federal Trade Commission, the FTC. So I'll just put up one of the letters that the FTC sent out. Pardon me for 1 second.
And while he's doing that, I would say the other thing that came to mind while Kiren was speaking was music. Music is a huge area where, irrespective of whether you're a more sophisticated party or not, people just don't often realize how much it costs to clear it and the rights that you have to obtain. So I know we'll probably get into that later.
I think we're going to be talking about music quite a bit. But so I just wanted to put this up. This is one of the, I think there were 72 Federal Trade Commission letters that were sent out to various social media influencers. This one was to Amber Rose. I'm not going to ask for a show of hands to see who here knows who Amber Rose is, but it's included as part of the letter. This is her, and this is, I guess, one of her Instagram posts. So effectively, without going into the letter, which we all noticed, the accuracy of the emojis that they included in the letter, they, probably somebody, some intern or low-level attorney there was diligently replicating the number of heart eye emojis. It's not 11, it's 12. But these FTC letters are actually really interesting when you look at them, and they're basically conveying, along with many other things, listen, whatever you think you may be putting in your posts, whenever you're referencing a brand in your posts, or basically, I think in this instance over here, right, the top, I don't know if you can read it, it says, I love this dress from Fashion Nova, right? And then she has a post, I think, of one of her kids, right? There's my kid in Child's Play clothing, and the examples go on. And what the FTC is basically saying is that there are advertising disclosure requirements that are required in commerce, and you're not abiding by those, and it doesn't matter if it's your personal feed. So we're lucky in that Kiren is one of the people, and certainly at her company, one of the people who is sort of functioning as an FTC guru in this space. So I just want to put it to you generally, how is this impacting your business?
Yeah, just a quick point on these letters. So the FTC, actually let's take a step back. The FTC has certain commercial guidelines for basically anybody who's promoting a product or service of an advertiser. They have to disclose a material connection between themselves and that advertiser. A material connection is basically any form of consideration. It's been something as simple as early access to a fall fashion line, so you get it before the public gets it, get access to it, so you have to disclose that connection. It can be something as simple and common as monetary consideration, or it could just be a free product. So these rules have kind of, existed for a while. The letter that was just shown, that's actually the first time that the FTC reached out directly to these influencers to say, hey, what you're doing is wrong. They've, issued these guidelines for, I think it started in like 2009 when they first came out with the regulations, and it was like really not on point for how this user-generated content works. So a lot of people were left to scramble to figure out, well, how do you disclose? Is this sufficient? Is this not sufficient? They, release updates here and there, and the most recent updates actually provide a lot more guidance. It's very clear. No, you have to use this terminology. No, you have to have it appear for this amount of time, and what have you. And on this type of platform, for example, Snapchat, where it's content that disappears, or Instagram stories that disappears, and there isn't a caption, how do you disclose there? And the FTC for the first time kind of gave guidance that, hey, you have to actually superimpose your disclosure directly onto that video content. So you'll probably see in any content that you consume, it'll say like sponsored, over a video. So it was very clear, but what the FTC also did was they kind of piecemealed, their updates. So they issued this thing, this like official press release, going through, here are the specific examples, and then like a week later or so, they started to do like a tweet Q&A, like a Twitter Q&A, to talk about, there's some confusion, we'll offer more guidance here. And in that Twitter Q&A, they specifically called out the YouTube, Facebook, and Instagram disclosure tools as insufficient. So because they're piecemealing what their rules are, many people don't even know how to get those rules. And I think that is like the biggest source of stress and confusion that arises. So within our company, I've been with Studio 71 for a little over 2.5 years now. And when I first started, I got tremendous pushback from the advertisers, from the influencers for having to disclose. As more and more enforcement actions have picked up, you started to get a lot more advertisers trying to make sure, hey, you're gonna make them disclose, right? We have to make sure that that they have to say that this is an advertisement or sponsored content. And influencers have now learned that they have to disclose. And since these platforms have, built-in disclosure tools, they're like, oh, great. On YouTube, for example, there's a small box that you check that says this is like sponsored content, and the video will show, and a small white text will show up, an overlay that says advertisement for about 10 seconds. And that should be sufficient. And so everyone's like, well, just click that. We no longer have to say it. We no longer have to superimpose this, overlay over our content. It can be a little bit more organic. And then the FTC tweets out that, hey, by the way, it doesn't count. So it kind of becomes an issue because the influencers are like, well, we don't want to do that. We have it here. And they still don't understand that it's not enough. It's insufficient to use those tools. So what we've implemented at Studio 71 is an external influencer-facing FTC disclosure policy that is attached to any agreement that we have with an influencer when they're going to be doing these sort of branded integration campaigns, that we have them sign off on the contract as well as the policy. And then we also have an internal monitoring policy to make sure that those disclosures aren't later on removed, or it's not, the content isn't changed in any way, to make sure that it stays there. So there are a lot of issues that kind of come up as people are trying to figure out, how do I even know what the rules are when they're being distributed in so many different avenues? And if you go to the website, I do this day in and day out, and I still get confused when I go to the website. And I'm like, well, where was this? Where was this? And it's like, I have to save the links because it gets very messy. It's not as intuitive as you would think to find those documents.
And I'll just because I looked at this yesterday, I went back to that, I think it was like a September 20th, Twitter conversation that they had back and forth. And you have to go all the way back in their Twitter timeline.
Yeah.
There's no readily accessible place to click and say, here's our discussion and guidance. You have to scroll back in time on Twitter and basically see what they posted.
Right, and the way I even came across the Twitter Q&A was because I was updating our policy and I was going to be presenting, and I was like, let me just check around the internet to see if there's been anything else. And it wasn't really that announced. It's like you had to be a follower of the FTC on Twitter, and I doubt these influencers are following
Right. How
the
many
FTC.
of those?
Yeah.
10.
And so it's like, I just happened to stumble upon it because this is my day to day, so a lot of these influencers aren't really aware of that.
So, I want to turn to Daniel for a second, because Daniel sort of represents something that, at least for me, is relatively new. We've all sort of been exposed in some way, shape, or form to cease and desist letters when people are using content without authorization. I've received cease and desist letters. I've sent my fair share of cease and desist letters. But recently, some of us have started to get what are sort of in lieu of cease and desist letters. Hey, before we tell you to cease and desist, maybe there is something that we can work out here. There's some sort of potential for the parties to work together. And Daniel, at Fox, you're at the forefront of that. Why don't you get into a little bit sort of what you as a non-lawyer are doing in connection with content protection?
Sure. So I guess I've been trained by my team of expert attorneys at Fox to also say it depends when it comes to all these questions. I guess this kind of leads into a little bit of what Kiren was talking about, where the term influencer is a very nebulous term. There are professional influencers like Logan Paul that Kiren represents, and there are kids who just want to create a YouTube channel because they're a fan of a particular brand or a film, and for them, or for us, or for the platform to expect that as they're clicking through these terms that they're even understand even a small portion of what they're agreeing to is, I would say on our part, very unreasonable. So in terms of how we deal with potential issues that might arise from influencers, we take all of that into context. I would say in terms of our ability to look for our content on the internet, we use technology. So I don't know how many of you are familiar with Content ID, but it's a tool, it's a technology that YouTube provides to rights holders to give us the ability to scale and monitor for our content, not strictly from the perspective of are they infringing our content. It also allows us to track our content from an analytics standpoint. So we use that as a data set to help inform our business decisions, not just from a legal standpoint, but from the perspective of, maybe there's a particular film that is getting a lot of traction on the internet or on YouTube that we weren't aware of. So one great example is Alvin and the Chipmunks. We have huge brands like Avatar. We, produced Glee. We produced the X-Men films, but for some very distinct reason, we've learned that Alvin and the Chipmunks has a huge following. And I think that was really born out of using technology to help us find that content and find clips that people are uploading, like fans who are using that in their home videos, or using the music behind the film. And what we learned is there are 3 elements to that particular franchise that just resonates with people uploading the content, which is animation. It has an animation element, it has a music element, and it's family friendly. So we use, I don't want to say it's content protection technology, but we use the technology that we have to kind of inform our decision making in terms of which fans should we reach out to, or which brands should we reach out to, or is there a particular genre that we need to put more effort into because there's a huge fan base. So that's kind of, my world is kind of an amalgam of various things. I sit in the corporate legal group, but part of my job is to help inform the business units in the context of what I'm doing and the data that we're ingesting to make business decisions.
And you also deal with technology companies a fair amount in your job, right? And oftentimes the interface between Fox and these technology companies. How's that experience been for you?
It's a battle. I don't think it's any secret. I think content creators have a love-hate relationship with technology companies. But the reality is that we do live in a world where, as a content creator, if we don't have a presence and we don't have a partnership with YouTube, Facebook, Instagram, Snapchat, etc., we're not doing our jobs in terms of engaging with the fans who are our fans who are on those platforms. So with respect to dealing with these platforms, I mean, we spend a lot of money in terms of media buys. We spend a lot of money in terms of working with influencers that Kiren represents or that Marjorie represents on these platforms. And I think one of the things that we struggle with is, from a business perspective, is we live, and I don't want to use this as a pejorative term, but it's kind of funny in the sense that we're an old kind of legacy media company that has to abide by very traditional forms of distribution. So, when we make a film, we release it in theaters for a set period of time, and then it goes into the home entertainment window where we sell it on DVD and Google Play and iTunes, and then from there it goes into free ad-supported medium. So within these distribution windows, we're constantly inundated by, one, kind of the market push. Should we distribute our content, whether it's a short form version of our content or outright engage with the audience in terms of the actual content we're creating, in terms of leveraging YouTube channels, leveraging the influencer community to promote our content. So I think it's just a constant struggle from a business perspective to work with these platforms and to adopt the new features and technologies that they're always kind of throwing at us. So it's a constant battle.
And just to follow up on that, on an interpersonal level, right? I mean, so for those of us who are used to working in entertainment and content industries, we know exactly who to call at a studio or production company to sort of deal with issues. Do you have that same interaction with technology companies?
Sure. So typically, we have a dedicated partner manager that a technology company in the media services group that Facebook or YouTube will provide us access to. I think the struggle between working with them is that they're beholden to kind of the bigger behemoth of what Google or Facebook is trying to do from the technology standpoint. So traditionally, like the way that we think about distributing our content, or the way that we think about engaging with our fans on these platforms, is wholly different from how a Google or a Facebook or a big technology company would want us to engage with. They just want us to essentially kind of unleash our content onto these platforms so that, one, obviously to promote our content, but it obviously drives traffic to these platforms as well. So it's a constant struggle where, we want to get our message out there, we want to get our brand and content out there, but again, we're trying to not give it away for free, obviously. So it's always that struggle and that message with these platforms.
And they don't, because we're kind of a company that's in between. So Endemol Shine produces content for networks. So MasterChef for Fox, Fear Factor for MTV, Biggest Loser or Big Brother for CBS. So we've been kind of the middle people where we found in dealing with the technology companies, especially as a lot of them have kind of expanded their business, which again, as he stated, it's not their core business, but it's kind of an ancillary business, and they realize that there is an opportunity in that space. They're looking at it from a very different scope and lens. And so we found the same kind of thing where having to really kind of reframe the individuals who you're working with on that side of the table and explain like, hey, sometimes these are things that we may not be able to ask of the influencers because they're our talent, and we're the ones that are providing that to these networks or these tech companies to engage in certain to create certain content. And literally we've gotten a litany of asks that I've had to push back. I'm like, I can't go to that talent's lawyer or that talent's agent and ask them to do X, Y, and Z because they'll look at me like I'm crazy. And they're like, why would you ask us to do this? They're not accustomed to that. Or conversely, especially in the digital space, a lot of these influencers are paid. They're paid for their likes. They're paid for the number of followers they have. So sometimes the type of things that they're asking from the platform perspective, they don't realize like this is actually that person's entire business model. So you can't, either you have to pay them more to do it or you have to dial back some of the requests, because for that influencer, their entire persona they've created is tied to, or it's tied to, a particular, they've created almost a character. And so some of these asks may actually be disingenuous to their followers, and it seems very inauthentic to the people that they're accustomed to engaging with on a day-to-day.
Is sort of the interaction between the traditional entertainment companies and the tech companies changing as some of those tech companies begin to open offices or expand in Los Angeles with content production?
Absolutely. The first level of change is they're bringing in more people from traditional media. So if you look across the YouTubes, you look across the Facebooks, you look across, and again, Google bought YouTube. So in terms of YouTube producing content, we are putting out a show. It's called Best Cover Ever. It's launching, I think, on the 20th of this month, and it's a big kind of shiny floor format with Katy Perry and Jason Derulo and Backstreet Boys. I don't remember, but like a lot of these big names that are part of this program, which I should know, because I hope no one is recording this. But at the end of the day, yes, it's interesting to see traditional media executives now in this new kind of infrastructure and framework. And even as simple as us trying to get a contract executed in order to produce a show, there are so many layers of approvals because, again, they're operating within this more traditional tech infrastructure. And it's like, that's not how this works in entertainment. Like, they literally, and this is Google, they had to personally, someone had to stamp, and there had to be like a stamp on every single page of an agreement. I'm like, no one does that. Like, everything is you DocuSign and you keep it moving. So like, just in terms of the delay in terms of for marketing asks, well, the creative person may say, since we're the studio that's producing it, we may present 5 scenarios to their marketing team to say, hey, does this work with you guys as advertisers, or does this work with the brands that you've acquired to have integrations into the show? And again, just the level of approvals. And I think it's probably somewhat frustrating as well, because, if you come from a Viacom or you come from another traditional media company, even though you have that bureaucracy, everyone understands their lane. So they may check off on this part of a deal, but they're not so engaged in all the aspects. And I think a lot of it is just learning how to play with each other in the sandbox and really kind of balance the risks.
So sort of taking that to a different area of the ecosystem. In traditional entertainment, there's sort of a pattern or a rhythm to litigation, right? There are certain commonplace types of litigation, whether it's breach of contract, breach of a distribution agreement, breach of profit participation claims, or IP-related claims. What's the role of litigation now and moving forward in digital media? And I'll open it up, whoever wants to address it first.
I'll jump in. We have handled a couple of litigation issues. I kind of referred to this earlier. So my company represents 1,300 YouTube channels within our network, and so we represent the content that lives on these YouTube channels. But many times we just have a rep and warranty from the person who's running that channel that they're guaranteeing that everything that they're posting complies with the terms of use of the applicable platform, that it's free and clear from third-party claims, that sort of thing. But of course, the content that we're a little bit more involved in, such as the branded integrations, especially when we're working with the networks, we have to make sure that, yes, there is no infringement happening before we deliver that content to the networks. But, with that kind of comes some issues that the influencers are, like I mentioned earlier, they're just not aware of their obligations. So they're used to doing things in their own way. They're used to not really, they post when they want to post. They're not used to, even if they sign a document, they don't care. They're like, it doesn't matter. Like, what are you going to do? So I think a lot of the issues that we face in terms of potential litigation is, do you pursue a potential breach of contract claim against an influencer? And it's a very, very tricky situation. Many times, we will have the influencer sign off on documents. It actually just came to my attention last week that one of our, top performing influencers, who is also the top pain of our network, who's constantly shirking his responsibilities and is not wanting to do anything, I just found out, oh, we don't have him sign anything. And I was like, well, what do you expect? If you don't have him sign anything, we have nothing to say to even, consider having that potential breach claim,
Although I think we can all think of instances in the entertainment industry where top talent doesn't sign it.
That's true, but it's
we don't sign something.
but it's a little bit more different in this context, I think, because it's just, I don't know, there's this expectation that the rules don't apply to them. And so because of that, it's like, you at least send an email, at least do something where we have a paper trail so we can show some sort of behavior that he acquiesced to whatever the deliverables were in that context. So recently, we had engaged this talent to promote a beauty product. We sent her and her father out to Hawaii. They got a really nice trip. All they had to do was, create this dedicated video where they're promoting this product and showing how the product was used while this influencer was in Hawaii. She delivered a product that was more of what is referred to as a shout out. So she did a regular video and then at the end was like, hey, by the way, I really like advertiser's product. And it was supposed to be a fully dedicated video showing her using it, really talking about it, interacting with the product. And it was, she claimed, I'm still owed my $325,000. And, the advertiser was like, absolutely not. And so what what we did there is what we do when any of those situations arise is, okay, we'll go back to the advertiser and say, hey, even though, this wasn't contemplated before, let's come up with a make good. What can we do to get you what you need without, potentially us being in further breach of contract. And just to take a step back, so my company, in my role, I negotiate the deal with the advertiser saying, hey, we'll get influencer X to promote your product, and simultaneously I'll negotiate with the influencer to say, hey, you're going to promote product Y of the advertiser. So in the scenario that I'm referring to, we negotiated a make good, and they said, okay, you know what? Let her go back. She can edit. She can, put in that footage so it's a little bit more substantially featured in the content, and we'll be fine. We sent it to her. She again sent back something that was not what was agreed upon. And it gets to a point then where you're like, well, we don't really know what to do. We're in breach. Normally, we could try to, negotiate, okay, let's find a replacement creator, to maybe deliver certain content at the same level, same stature as the breaching creator. But sometimes that doesn't work because it could be timing of the campaign. It could be we needed this influencer specifically. It doesn't always work. So in a rare, twist, my company decided to pursue action against this influencer for a breach of contract claim. And we're currently in, it's pending litigation. And so it's just like, it was a move that kind of showed, and I can't think of any other MCN that has actually done this, but it was a move that showed, influencers, like your obligations, like you actually, when you sign a document, it's a legally binding document, and you're not above having to deliver these deliverables and expecting that you would still be entitled to that $325,000 after not doing what you agreed to do.
Yeah, but I feel like that's absolutely the exception and not the norm,
Yeah.
because our business is tied to personalities. And so what you don't want to be is the network or the studio that's known for suing talent. Like they'll never work with you again. So
Yeah.
it's a balancing act. And although, we're coming at this from a legal perspective, the reality is everything is driven by the business. So that is the analysis, especially as an in-house lawyer, that you have to do, is to look at the business. And the business in terms of, do you want to upset the advertiser who's paid your company to provide X person to be a part of X campaign? And is there another way that you can either have them, like she said, a make good that would be sufficient? I've gotten into conversations with those advertisers of how do you even quantify if they say 5 of the things that we ask them to say, but not the 6th? And what type of value? And if it's supposed to be during this time frame, is there more value from it being in the premiere episode versus one of the finale episodes? Because if the show does well, arguably there's going to be more people that are watching at the finale as opposed to the first episode. So like those are literally the type of business conversations that this type of the threat of litigation, both from us against talent, but also that brand against us. It's all boils down to relationships.
Yeah.
And even in terms of other areas of litigation, kind of the obvious is trademark protection or content protection. So what if an influencer is going beyond the scope of what they're supposed to be providing, and they're infringing upon our marks, or even sometimes it could be a fan, because again, when you're talking about user-generated content, this is literally anyone who has the ability to post something on any platform. And so we've had instances where a fan has really infringed upon either putting up entire episodes or just have used our marks in a way where they're now monetizing it. And so we don't necessarily want to outright create this situation where fans are being sued. And so we found a way to actually engage that fan where we took over the rights to the page, so they no longer had the administrative rights to post, and we monitored everything that was being put up. But then we hired them as a consultant because it was clear that they had this zest and this love for the brand. They were more familiar with the benefits of what they were doing on social media than arguably our marketing and our digital team was. And so it really became a scenario that it worked out well for all of us, where we still had control over our marks and over our brands, but they were still engaged and actually were paid by us to do so.
It's very generous of you.
I know, but everyone is happy, and that's at the end of the day. And now we don't have to hire Dan and pay all his fees.
Thanks, I really appreciate that. I just want to make sure I get Daniel's input on that too, because being at a studio, I think a lot of us remember the sort of Napster era of scorched earth studio and record company approaches to this. It really does seem like it's changed.
Yeah, I mean, we are very cognizant of not wanting to go down the road of the music industry and how that impacted their business. I guess the only thing that I can add to this is that, I mean, we realize that the internet community is going to use our content whether we like it or not. And I think to the extent that, you know, there's obviously someone egregiously abusing our films or television episodes, you know, we'll look at that. But for the most part, I mean, we're not in a position where we're trying to alienate our fan base. If it's done respectfully, and we feel like there's, you know, we're always balancing the legal and business perspectives here, but like, we're just not going to go after individuals outside of, you know, someone just straight stealing our stuff to profit off of it. So I would say as a company, we're very cognizant of that. We're respectful of the use of our content. I mean, you know, obviously we're dealing with fair use issues all the time. So I'll just say that. I mean, I can't think of one example in recent years where we've actually, you know, had to approach someone who was abusing our content from like a user uploaded standpoint. We always try to be very judicious about that. So.
Hang on one second. We'll get to questions in a moment. And then also, just as a reminder, if you have questions, you know, let's use our digital interface so that we can line them up and get through as many as possible. One issue that Marjorie touched on before was the issue of music. And as we were preparing for this, Kiren had a very particular issue that came up with respect to user-generated content. So we have it to show you guys as a preface to her sort of discussing what happened in this situation. And it's more entertaining than just me talking anyway, so. So I think this video got like 14 plus million views or something like that.
Yeah.
And what was the problem that came up?
So this was like a pretty big thing it was a viral thing, this Running Man challenge, which was using that song and people would do this sort of content with it. And, you know, we license a lot of the clips that we have exclusive distribution rights to. And this clip was one, we have like a business team that is used to licensing clips. We have a standard clip license form. They can just populate the template and send it out. If there's negotiations, then obviously legal is looped in. And this was going to be licensed to Google.
You want me to show it?
Yeah, to be used in a commercial. So it was used in a Chromecast commercial, and that was the intended use, but what happens is that, what you touched on earlier was like music is used without even thinking like, hey, this is actually a popular song. You're going to get a claim. And so we had our business person just send out this clip license. And then, we're negotiating, and one of our junior attorneys had, she was working on it. And I was like, just make sure you check that there's no claims on the song, on the clip license. And then she went and checked, and there's so many claims from the publishing company, and we're representing and warranting. So Google, hey, it's free and clear. You can use it in TV. You can do it whatever you want. And so all of a sudden, in the middle of negotiations, we have to say, hey, we didn't realize it was this clip, And so it became an issue where now we had to basically say, I know we said it's free and clear. It's free and clear in that we have the rights from this guy, Guava Juice is one of the top YouTube influencers, but we do not have the rights for the music. And so there was negotiation. In the end, Google did take on all the responsibility for any financial obligations that came with the use of the song, which is not always going to be the case. But, we were very fortunate in that situation.
Yeah, and aside from music, the other thing that we've noticed is a lot of influencers, depending on where they're at, there could be artwork in the background, there could be murals, or so there's even someone's tattoo. All those things, there's intellectual property rights that are attached to those, and there's an owner and there's someone who has a valid claim, and those are just the type of things that can pop up at the last minute, where the actual creator doesn't realize that, oh, I actually have to clear this. I can't just use it in this fashion. Once you're monetizing something, that changes the entire, the fair use argument.
Yeah, and we were working on another campaign recently with a new influencer who's coming more from the traditional context, and she had to promote a product, and we're pushing, hey, the deadline's coming up, it's coming up. Make sure there's no logo. We always advise no logos, nothing in the background, especially when it's the vlog sort of content. And it comes to us, she's promoting some sort of like a robotic toy sort of thing. And it comes to us, and we're supposed to deliver it, and she's wearing a Star Wars t-shirt, and and I'm like, oh no, like, what are we going to do? And, then it becomes this whole issue, and, we have to be like, okay, like, how do we creatively come up with a way? Because you can't blur it, the advertiser's not going to be happy. And it's like, obviously, if Disney ever wanted to come after it, they really could, because it's also promoting a product that is very competitive with the type of toys that Disney would try to sell for Star Wars. And Star Wars is going to be released very soon. So the timing of it is just very unfortunate.
There are a couple of questions that came up as I'm looking through, and I just want to synthesize a couple of them, because a couple of them hit on the same topic, which is about influencer campaigns and whether a lot of them fly under the radar, and how many of them hinge on people who are being paid to like and follow certain campaigns. So if you guys want to address some of that in that context.
Yeah, I feel like, honestly, I think the majority of them probably do. Kiren was talking about the FTC and just how convoluted it is in terms of what they're putting out for guidelines and that sort of stuff. And I'm of the school of thought that actually a part of the reason was because they're still trying to figure it out. We've seen the evolution of technology. We've seen the evolution of these type of tools, and like she said, where you can check a box in certain platforms that wasn't always there. Adding ads, hashtag ad or hashtag sponsor, and so I feel like there's not an enforcement mechanism whereby you can really track every single thing. I think what's probably happening is, as those campaigns become the 4 million or the 5 million or the larger kind of ones that go viral, those are often the ones that unfortunately get good and bad. They get good and bad attention, and so that's when those type of issues really, I think, come up. I think also there's so many influencers that are just doing things on their own. That's the other thing. Like, their legal team could be someone who's like a friend of a friend who is a divorce attorney, and they're like, "Oh, you're a lawyer. You can handle this for me." So they're not paying attention to those type of issues.
And I'll show one question. I don't know if anybody's aware of this or not. Is anybody aware of how the FTC addresses disclosures for paid likes?
Yeah, they actually, in their most recent updates, they kind of said, yeah, that is a potential issue. And that was about it. So it's not really clear because there's not a way to disclose that. You know, it's the issue with any sort of FTC disclosure is that it has to travel with the content. So in a YouTube video, for example, it's insufficient to have a disclosure in the description box because if that embed link is then posted somewhere else, that description box doesn't travel with the content. And then there's like, you know, some platforms such as Snap, which didn't really give you the ability to disclose in a caption and what have you. So with likes, it's unclear. And they kind of punted the issue, kind of what Marjorie's saying, where it's like, well, we'll see as this progresses. I work on a ton of branded integration campaigns. Like it's a large part of my day-to-day. And I still don't see this as like the type of deliver, although it happens, it's not the deliverable that is still being pushed out. It's still like we want the content, we want somebody actually saying something, not so passive that you like something and hopefully people will notice that you liked it.
I will put this question up, which you all can review, about what are the actual risks regarding the FTC. And I just want to address this quickly before you do. Kiren, because, you know, this is something that when you're outside counsel you deal with pretty frequently, especially when you're representing, you know, more startup level companies. This is one of the classic things that Eve, I think, talked about, you know, on the last panel. You have to advise your client about the potential risk, but you also have to advise them that it's unclear what the probability is, right? So far, I think the FTC in the influencer space, at least, sent out a total of, I think it was 72 letters. So you've got to imagine the percentage is pretty small as opposed to the total ecosystem. At the same time, you know, we don't know if you're going to be one of the next batch of 72 or 720. We don't know what the enforcement efforts necessarily are going to be, what the scope of them are, you know, and then it becomes up to the business people to assess and, you know, either take the risk or not take the risk. I'll turn it over to you.
Yeah, and I think it's kind of hard to determine what is considered like a non-top level influencer or brand because it really depends how viral does that go. Mm-hmm. Earlier we showed the Amber Rose post where she's promoting Fashion Nova, right? Which is really heavily promoted on Instagram, but it's not what you would call a top level brand. It's a certain type of influencer that is usually promoting that brand, and within certain communities, it's like pretty clear. There's also, you guys are probably familiar with like that slim fit tee, you know, that was like going around everywhere, but it's not necessarily a top level brand, but I do think that it attracts attention from the FTC. Recently, this year, within the past couple of months, they pursued an enforcement action for the first time against influencers directly. It was Counter-Strike, Lotto, something like that. I forget exactly what the influencers' names were, but they were promoting this video game that they had like it was like a app to like supporting the video game that you could buy skins for the video game itself. And they had like, you know, a financial incentive because they were invested in the company, but they weren't disclosing them. They were just like, oh, check out this like website, but they weren't disclosing that, hey, when you actually buy content from the website, the money comes back to me. And, you know, that was the FTC their first enforcement action against influencers directly. And those influencers, there's two of them, it was Trevor Martin and I forget the other guy's name. Now they have FTC oversight for the next 10 years for all areas of their business. So they have to do regular reporting. In that case, they didn't actually have a financial obligation, but many times there are. So I think it really depends how viral, how egregious are those FTC violations.
All right, let's do one more. Standards of rules and behavior on YouTube and other tech platforms. Anybody want to address that?
I mean, they standard. There are certain. I think just like how networks have actual standards and practices, and a lot of it depends on what type of content and where it's going to be distributed. So, I mean, I think there's kind of the basic ones that I've seen where, you know, you can't use defamatory language, and you know, there's like nudity and, you know, a lot of kind of the same things that I think are consistent for broadcast platforms. I think the difference is it's still gray. You know, I mean, no one wants to be that attorney or that creative exec that allowed something on. But like, for example, my last job, I worked at Comedy Central. You know, so I mean, you can only imagine from smoking weed and content to, I mean, you know, the types of things that me as the lawyer would have to say, well, and and the thing about digital is you can always pull content down. So there are different standards and different criteria that we would allow, especially for our digital team, to really push the envelope, because at the end of the day, if there is an issue, you can pull something down offline in a matter of hours versus having to actually go back and re-edit an actual episode that's going to be on TV.
One thing that's actually currently happening is earlier this year there was this event that became known in the digital community as adpocalypse. So what happened was, you know, advertisements are just automatically run before videos that when you get to a certain threshold, you can start monetizing your content on YouTube, for example, and you'll just have pre-roll before the videos start. And what was happening was advertisements were being run in front of these like violent videos, like ISIS beheading videos. And advertisers all of a sudden pulled all their money from YouTube. They did not want their advertisements, any of that inventory anymore. And so YouTube is left to scramble to figure out, well, how do we even monitor, you know, for all the content that's posted to YouTube every single day? It's like, how do you even monitor and how do you make sure that that content is not what advertisements are running against? And so now there are starting to become these standards and practices where they're saying, okay, if you mention, you know, if there's a mention of guns and this and that, and companies like mine, we have an in-house media team that is combing through all of the content that we represent on those 1,300 YouTube channels and saying, okay, this is brand safe, this is not, and it's a painstaking process. And it also there is, I think, there's an automated process to it, but it also leads to issues because it's like, you know, maybe you said the word gun, but it wasn't in the context of like violence. You know, it was just it was used in a different way. And now you're not getting the advertisement run before your video. And as we've discussed, this is how these influencers make money. And when that content is first posted, that is when you're going to get the most engagement. That is when you're going to get the most revenue for the eyeballs that are on your content. So even if YouTube comes up with, let's say, a 24-hour expedited like human review process, which from my understanding, they're not going to do. There's no real plans. It's like you can't really do that. In those 24 hours, you've lost so much money from there. So it's not really clear where they're going to do.
Is that sort of a precursor in your mind for something akin to a rating system for this type of content?
Yeah.
You think that's coming?
Well, I think there might be more robust sort of like standards and practices than now. I don't know like how you would really the rating system is like it's a little hard still. You know, I think what you might see more of is like a more robust like standards and practices, so people are very aware of if you say, you know, these words in this context, like or even these words, it's going to automatically trigger, you know, demonetization. So just be aware of that.
Right. Well, and I'm not saying, you know, somebody's going to label a YouTube video R or G or PG, but if you know that these words take you out of the 4-quadrant bucket and into the 3-quadrant bucket, and your ad revenue is going to be less, people are going to start paying attention.
I think so. I mean, we see that even within our company now. We have also in-house talent managers who have to advise the talent, hey, if you use the word sexy, it might like trigger this thing and you're not going to be considered family friendly.
I think we need to cut it off right here in terms of time, but let's give a hand to our great panel.